Prop 23. Proposition 23 is a proposition to regulate dialysis clinics. Currently, the Department of Public Health regulates dialysis clinics based off of federal guidelines. Dialysis treatment is also mostly paid for by Medicare and Medi-Cal, but private insurance is also covered, with private insurance usually spending 4 times more. And there are 2 major companies that run dialysis clinics in California. Both of them are private for-profits. Voting yes on this proposition would require these dialysis clinics to make sure that their one licensed physician is there at all times while the dialysis clinic is running. Currently, it's only about a quarter full-time equivalent because they're needed there to just basically train people. But this requirement would ensure that if there's an emergency that happens, there'll be someone there. And that it would also increase requirements of reporting to see of infections, and as well as prohibit refusing service based off of where you got the money to pay for the medical treatment, as in the difference between Medi-Cal and private insurance. So that itself has been codified in state law elsewhere. It also implements a block on any closures of dialysis clinics without Department of Public Health approval. As a result of these increased regulations, there's a cost around tens of millions of dollars a year at the local and state level governments to enforce them. Supporters say that these requirements are necessary to make sure that there's no discrimination based off where you got your money from, and that dialysis patients are the chance of mortality of a dialysis clinic patient is high due to their condition. Around 5 years is about the rough estimate, and that they should deserve paying so much for having at least an emergency services in case things goes wrong. Opponents, on the other hand, say that given our current shortage, that if we make this requirement, we are diverting doctors away from more more pressing concerns, and that it causes clinic costs to go very high, which can threaten their financial stability and may cause them to get closed. And that this proposition, just like the proposition we had 2 years ago, is just another strategy placed here by unions. This proposition has $6.2 million for and $60 million against, and this proposition was placed on the ballot by the union. This proposition requires a 50% amendment by the state legislature to make any changes. Any questions?
No questions.
Okay, so we're on Prop 24, Consumer Privacy Law. And this story starts with Alistair McTaggart, a San Francisco real estate developer, who decided to sponsor a ballot initiative aimed at protecting consumer privacy. He was worried about the amount of data that companies collect in the process of doing business, including your personal data, your health data, financial and preference data, and other types of data. Businesses use this information to serve customers, but they may also find other purposes for this information, like selling it for further profit to other businesses who might use it to, I could give you an example. Like if you signed up for we're trying to sign up for car insurance online, which I have done before, they might sell your data on to a company that sells floor mats for cars. And that company might come to you and advertise their floor mats for your Toyota Prius, which you might want to buy. So, as McTaggart was trying to get his initiative on the ballot, the California legislature got interested, expressed interest, and they worked with him. And together, McTaggart and the legislature produced the California Consumer Privacy Act, which became law on January 1st, 2020. So 9 months ago. The CCPA, the Consumer Privacy Act, requires businesses to provide 7 rights to consumers. And these are the right to delete and access stored data, the right to refuse the sale of that data, the right to know what's been collected. It requires companies to keep the data safe, and it requires an easily accessible "do not sell my data" button. And it also provides protections for minors. So McTaggart says that since 2018, the landscape has evolved with new technologies, capabilities, and uses for data. And so he felt the need to put another measure on the ballot. After passing the CCPA through the legislature, he said, well, we already need to make changes to this thing. So he put up Proposition 24, and it does 5 things. It adds 15 new protections, including restricting onward transfer of information, the right to opt out of geolocation services, the right to correct data and restrict the uses for the data, and stricter penalty for businesses. And it sets up a new agency called the California Privacy Protection Agency, taking over from the California Department of Justice in enforcing this law. And it adds new language. Quote, the law could be amended to improve its operation, provided that the amendment does not compromise or weaken consumer privacy. This is designed to keep the powerful tech companies from weakening the law. The last thing that this initiative does is it delays implementation of the law for 3 years. So the fiscal impacts of this proposition are it would cost us at least $10 million a year for Consumer Privacy Protection Agency. And this would come from the general fund. And just for comparison, the general fund is about $160 billion a year. So 10 million is really just a very small drop in the bucket for your consumer privacy. So on the next slide, supporters say that it's really important to protect CCPA from the powerful tech industry. And that is McTaggart's main claimed goal in trying to get this initiative passed by the voters. And supporters also say that there are new protections for consumers. Opponents say that the problems outweigh the benefits with this initiative. This initiative is 52 pages of fine print with unforeseeable consequences, is what they say. They also say it's a missed opportunity for an affirmative opt-in system for data sharing with companies, the type of system that they use in the EU. Opponents also say that this initiative reduces the number of businesses that have to comply with this regulation, and it also changes the rules shortly after the CCPA was introduced, and small businesses are really struggling to get on board with the CCPA, and they're immediately trying to change it. So this was an initiated state statute, so it was put on the ballot by signatures.
Okay, we have no questions, so we can go on.